Hi and welcome everyone. First of all, for the final class of Vestralex online community classes, this is a humble initiative that we've been able to undertake with your support and the kind guidance and blessings of our seniors and guests. For this class, Shri Avtar Singh Rawat sir has very graciously agreed to take us through the overview of fundamental rights and reasonable restrictions. Little about sir. Sir is a senior advocate of the Uttarakhand High Court, of the Honorable Uttarakhand High Court. Sir is the president of High Court Bar Association of Nainital.
I do practice in Supreme Court, High Court, Delhi High Court. Still, keep on struggling. My family is in Delhi.
Practices in all the various courts, obviously including the Honorable Supreme Court. And coming to that, so sir is again a student, a fellow senior of ours from Campus Law Center, Delhi University. He was designated as a senior advocate in 2010. Sir has had the occasion of initially practicing in Delhi courts as well. He has previously served as the Additional Advocate General for the state of Uttarakhand in the Honorable Supreme Court of India from 2002 to 2007. Sir was also appointed as the Senior Additional Advocate General for the state of Uttarakhand at Uttarakhand High Court. He has represented the Union of India in the Honorable Supreme Court as well as the High Courts at various occasions, of course. So it is our very deep privilege and it is our pleasure to have the occasion and opportunity to learn from Sir, to hear his views and to be able to make acquaintance with Sir today. Sir, I thank you very much for graciously accepting us our invite and addressing us on this very important topic. And I hand over the class to you, sir.
Thank you very much, Kesha, and all your team. This is a very good. These steps, what you have taken, that you are contributing, you have planned to contribute to this society as well by having this community classes. And I'm thankful that you have invited me also. I was, in fact, in a tour somewhere, I was just around. But then young people, once they called me up, I've readily agreed. So I, once again, thank you, the entire team of yours, that having given that opportunity to me. And since it's just a conversation among us, all lawyers, or to the community, those who are going to get benefit out of it, I'll not say much about anything else. But then the topic which is given to me is the essence of the entire legal system. Everything, it is a foundation stone of the entire legal system. All laws and everything evolves and goes around this fundamental rights. As all of you are very well educated, you are well exposed in Delhi also. And I think probably you must be knowing much more about fundamental right, much more than me. But still, I'll just say that fundamental right, as you all of you know, that the fundamental rights is basically a common rights and natural rights of a human being. Inalienable. When human beings, we are a constituted of a society. Each individual has got its own basic rights. What are those basic rights? Like every day we perceive in our life, our freedom, sleeping, eating, so many other things are there, which we call basic human rights. Before I come to the fundamental rights as such, I'll just give you a small background of this entire scenario. As all of you know, that our country has also gone through a very struggleful life initially, when we become a slave of so many other things, initially by the Rajas, landlords, feudal society. Then thereafter the British Raj. There was absolutely separation of one's natural rights, basic rights. You know that Begar system was there. Landlord used to torture each and every individual. Thereafter, you know that Rawat Act came when the British were ruling us. There was arrest, torture, so many other things. There was no basic rights of human. The rights were not. There was no machinery to enforce it. Then what had happened was some of our leaders, particularly our Congress leaders of those days, those days Congress was the one. They had their exposure to the Western societies. Western society also, after the turbulence in the society, they had also, like the Magna Carta, Royal Charters of King John. The process of democracy was much earlier in those Western countries. Our people, those who were working in taking their education, their exposure in Western society, they also had this feeling of a democracy in a country. Democracy means opinion of the people, that we should be governed by the opinion of the people, not the Raja, not that an individual person, a ruler. So this concept of the concept of democracy also brought this kind of there must be some rights which would be enforceable, so that the atrocious regime by a single monarch or a person could be avoided. And ultimately, you know that what had happened was there were so many other similar movements all over the world. England's Bill of Rights were there. The American Bills of Rights were there. Then ultimately, taking some clue from those by our the educated people, those who are educated in Western countries, they also started, and you know that a committee 1928, the Jala Nehru committee was formed. They also then thereby dominion status they sought from the British regime. And ultimately, this socialism, concept of socialism 1936, they also visualize. And slowly and steadily, with the galvanizing the forces of people's sentiments, ultimately the democracy, our freedom struggle, step by step, moved towards, and ultimately we got freedom on 15th August. And that was a day after the independence. Our politicians, our leaders, they thought that whatever experiences they have accumulated throughout these years, that must be translated into into our constitution. And this very inalienable basic human rights must be a part of our constitution. And constitution ultimately, you know that Dr. Ambedkar was the chairman of the draft committee. J.B. Kripalani ji was the chairman of the subcommittee who has ultimately drafted this fundamental rights. And fundamental rights, then with their a lot of experiences, ultimately they have said that fundamental rights, they enumerated, discussed, and ultimately they came to conclusion. These are the 7 fundamental rights initially they put, including the fundamental right. A right to property was also right, which later on 1978 was amended and was excluded from fundamental right. And it was put in a category of 31A is a right of property, a constitutional right. Now, the fundamental right, as per the scheme which our framers of the Constitution, they ultimately envisaged, visualized, was the right of equality, because if you see that the Constituent Assembly, while discussing, the Dr. Ambedkar also say that what are we seeking for? The liberty for what? Ultimately, there was a existing uh, discrimination in the society. In order to reform that society, they said equality is the founding right of all other rights. The right of equality, which was visualized, and ultimately they have put it apart from that. This part third include, that part third has got Article 12 to 35. 12 is a state. They define what is a state, because ultimately the fundamental rights are given against the invasion of a personal right of an individual by the state. So the state, that was also made a part of the fundamental right. 13, any existing law which in contravention would be void to the extent of inconsistency, that was also made a fundamental right. And then the pride importance right to equality, which is Article 14 to 18. They have put this categorized in the sense, what is right to equality? Equality in what aspect? So right to equality was placed in Article 14 to 17 of the 18 of the Constitution, and it was a principal foundation of all of the rights and liberties guaranteed to the citizen of this country. And equality before law was Article 14. Article 14 was equality before law, that the Constitution guarantees to all its citizens equality before the law, and it means that the state cannot discriminate against a citizen on the basis of its caste, creed, color, sex, religion, place of birth, etc., etc. So this was a foundation. Once you place this equality right, equality in all aspects, that all further laws emanated from this laws. Then social equality, another was that the social equality, Article 15. Article 15, social equality and equal access to the public areas. Supposing the park and other, the earlier experiences they had, that in our society also, like the people were divided in very caste, creed, and untouchability kind of thing, and they were not allowed to freely move around the public places. That experience of there was also reflected in Article 15. And they say that nobody can be discriminated on the basis of caste, color, language. Every person shall have equal access to public places like public parks, museums, temples, bathing ghats, etc. And then this third, the very important right, because at those point of time, the education was also not that and now we, as Indian citizens, are more literate than those days. But then because of that inequality, then the framers of the Constitution, they also visualized that equality in matters of public employment. That was a day we were hardly any industrialized this thing. The country, slowly in the industrialization was being done under the supervision of the Nehruji in that mixed economy. And jobs were being created so that the life and the economic condition of each citizen gets improved slowly and instantly. And then this particular Article 16 was also inducted in the Constitution. It was placed under Article 16 of the Constitution, laid down that the state cannot discriminate against everyone in matters of public employment. All citizens, they would be eligible to apply for government jobs. There are some exceptions. So slowly, that thereafter, lot many, the Constitution, our Constitution is the most flexible Constitution. With the passage of time and with the necessity, it goes on evolving itself. And then under this Article 15 also, there's a lot of evolution. The reservation has come. The Supreme Court interpreted this Constitution as the most liberal manner. And then these downtrodden and deprived section of society were also given certain privileges. That is also a reasonable restriction in a kind, that absolutism is a utopian concept. The absolute equality cannot be possible. So therefore, this equality before the employment, in matter of employment, every person will be equal. They will be given all chances. Then the worst thing which was prevailing in those days, at the time of framing this constitution, was our society was badly caste returns, divided in many ways, and the worst concept was untouchability, which is still prevailing. That I can't dispute it. The abolition of untouchability was put in Article 17 of the Constitution, which say that we hereby abolishes that concept of untouchability. Practice of untouchability was made as an offense, and anyone doing so, discriminating on the basis of untouchability of anyone, was made offense. So this is a most inalienable human right. Everybody, Noam Chomsky, that Noam Chomsky was is still a great linguist in America. He said everyone is born with blank sheet of paper. Here we make this, somebody is a caste of this caste, that caste, and ultimately we discriminate untouchability. That rights of their natural right was, somehow that taken away. But this section also made it as an offense if somebody discriminates someone on the basis of untouchability. Then the abolition of title, that our society was suffering from landlord, there's atrocious nature. They were not given proper food. They are hardy and landless laborers. They were kept as a slave. So that was also very important facets of that society at those days. And that was also taken care by the Article 18 of the Constitution of India. And this title and other these Bahadur, Rai Bahadur, Khan Bahadur, these in order to pamper certain section of society, the British government, and ruling on us, has coined up these concept that was also abolished. Then comes second stage of the rights of fundamental, which was put under the category of fundamental rights, was the right to freedom. Freedom is a big the right, the freedom of various kind. So ultimately what they have done was these rights were put on Article 19, 20, 21, 22. These are another category of rights. These four rights which they have said, the freedom of expression and speech. I'll come to later that freedom of expression and speech, these were sub clauses of Article 19, in which there's a freedom of speech, of expression, freedom to assemble peaceful without arms, freedom to form association, freedom to move freely throughout the country, freedom to reside and settle in any part of the country, freedom to practice and profess any profession, but certain reasonable restriction. These are the concept that reasonable restriction, in keeping in view the integrity, sovereignty of the country and public morality, the reasonable restriction had put, but this freedom, which is inalienable to humankind, was also put right from Article 19 to 22. And you know that what had happened was ultimately, the one thing was very opinion in democracy. Democracy means a government of opinion. But the famous, until date, it has not been there, that the freedom of press is not made of fundamental right. Freedom of speech, of course, was there, but freedom of press, how you can have a healthy democracy, that's because lacking. Unless or until you give a freedom of press, the democracy cannot be as healthy as one can think of. Then these sub clauses under clause 1 of the freedom of speech and expression were also from time to time it were interpreted by various judgments by the apex court, and it has also evolved in many ways. But ultimately, the Article 21 is the one which I have seen throughout my these days of being in legal profession. I have seen the maximum evolution which has taken place by way of interpretation by the courts, various courts, is Article 21. Now, under the interpretation of this Article 21, you would see that how many things have come: health, hazard, drugs, so many other things. You are all rights which the affects a common man on day in, day out. The courts have been interpreting and evolving this, right of personal life and liberty rights. And it included, you see that Maneka Gandhi's right to travel, and this many spheres this right has evolved, and our courts have given protection to us. So thereafter, the another rights, the fundamental, which was put under the category of fundamental right, which was a harsh reality of then society, still today, is the exploitation in various kinds: child labor exploitation, immoral trafficking, and this enslavement, beggary. So these rights were also put under the right against exploitation was put under the Article 23 and 24 of the Constitution. And thereafter, you see that another category has come, that Article 25 to 28. 25 to 28 was that since our country was a diverse in nature, diversity is all still persisting. We have got various kinds of influences, like time again, we have been enslaved by Portuguese came here, so many, the Britishers came here, along with this religious, the various, after partition, also the race, religion, caste, there was a diversity in our country. So we have got the various religion people, those who profess, preach, the religious of different the sect. The Constitution was also, the framers of the Constitution were also aware of this fact, and therefore, in order to protect their the concept of secularism, which we have taken from initially from French, the Constitution, that secularism would survive only if, and therefore the society will survive this, in order to some way remove that conflicts in this society between various sections and sections. This particular, these two articles, freedom of religion, to profess any religion, race, creed, and everything, it was given in Article 25 to 28. Then, as we have said, that we have a very different kind of section in society, minority sections there, minority was there, like Christianity is there, Christians are there, Muslims are there. Then the Constitution also say that so far as the imparting education is concerned, they are free to impart education, but with certain reasonable restriction, means that the standard of the education has to be maintained. And the government was not even that barred from putting some reasonable restriction. Then these two sections, like 29 and 30, was given that freedom to the minority section to have an educational institution of their choice, subject to certain reasonable restriction. Then comes the Article 31. So you see that we have said that 31 has got a saving clauses, various saving clauses there. And this 31A was inducted in 1978 by putting this right to property in, because there was, with the developing society, the compulsory acquisition of a land of an individual was conceived. Otherwise, once it becomes a fundamental right, you cannot progress ahead, because there would be many litigations. So that in order to set off that particular restriction or some problem, and the continuous development of the society, that fundamental right of property was put under 31A, and all other, in order to achieve this goal, A to D, that's in Constitution 31A to D. Some saving clauses, existing laws were saved, whereby you can have the acquisition of a right property of the person. Therefore, the most important, the framers of the Constitution were quite alive with the fact that since we have given certain rights to its citizen, then how these rights would be enforced. Then the liberty to each and every section of society and individual was given the constitutional remedies. The Article 32 and 226 were placed in the Constitution, saying that since we have given all these rights, but supposing the state encroach upon those rights, they invade or some individual invade your rights, how to redress your grievances. And then liberty was granted in Article 32 to enforce your fundamental right. You can, any citizen, the one who is aggrieved of being infringed of his rights, then these rights 32, that one can go to the Supreme Court and say that these are my rights, fundamental, which is fundamental nature, have been infringed or invaded by the state. To that extent, the court would redress as per the provision of the Constitution. So the remedial, the constitutional remedies were provided under Article 32 and 34 and 35 is again the saving clauses are there. So these are the 12 to 35 were placed ultimately in the category of fundamental rights, which are very much fundamental and basic natural rights of a human person as an individual. And this was placed just because of the growth of an individual and growth of our country. If you suppress someone's, supposedly there's a restriction that a person cannot go into particular institution because it is meant for somebody. So therefore, the growth of that particular person is restricted. And the framers of the Constitution, after having visualized the past experiences and the experience which they have gathered from the most advanced, the Western societies, and these were included in the written constitution of our Constitution, but somehow that, as my personal views are concerned, but still those rights are not fully been, implemented. Every person has to go, and now over the years, this apex court time and again has come up with, when the person, those who are not capable of resorting to redressal of their grievances, then PIL was also, so the suo motu cognizance was taken by the courts, and many times the courts did try, and I may say that the apex court has done tremendous job, particularly after 1984, when this PIL was, concept of PIL was, blown up fully, and many people, they've got so many addresses, like Olga Taylor stood down, many judgments, environmental, MC Mehta, and T.N. Godavaram, which affects each individual in many ways. And the Supreme Court has never failed in its endeavor to enforce the fundamental rights of an individual. But there are so many other things apart from this, the all niceties of fundamental rights. There were some criticism also. There are so many other things. Inequality still persists. There are hundreds of people, those who are unemployed. The economic disparity is there. And the one thing very important which the government has done, that 2002, by way of this 86 amendment, right to, otherwise you see that those who are very downtrodden, at the bottom of the society, they were not in a position to provide the children's even elementary education. That the 2002, by way of this 86 amendment, it was also brought under the category of fundamental right, right to education to children below the age of 14. That was also a very revolutionary action which the government has come up with. But then still, despite all this, there are so many the demands that economic disparity, old age pensions, and economic assistance to unemployment person, give employment must also be put in the fundamental right, but that everything cannot be cured by the fundamental. Otherwise, the fundamental right would loses its that sanctity. So these are the few things which I want to say about this. But so far as the reasonable restrictions are concerned, reasonable restrictions, the first thing in under Article 19, all sub clauses 1 to 6, there also these are the rights which are of nature. If it is not regulated, might go haywire, and the basic purpose of our giving those freedom be would be in a problem. So therefore, the government, apart from the premise of our constitution, apart from giving those solemn rights to individual enforceable through courts of law, has also given some the reasonable restriction, though those reasonable restrictions are not well defined. It is basically on the interpretation of court, and under the garb of reasonable restriction, there are so many the executive orders which are not very palatable, in the sense that directly, indirectly, like MISA Act, which you would see that 2-3 years back, it was miserably, misused. This MISA Act, NSA Act, we invoke against any political enemy, but the fact remains, that the reasonable restriction has to be there. Otherwise, there would be chaos, anarchy. If you do not put, supposing we give the right to form union and association, and we allow them arm also, and then what ultimately would happen is the chaos, anarchy. So therefore, the framers of the constitution, despite the novel, the reason they had while framing this constitution, they also thought that in order to our society is still evolving. The literacy rate is not as it is in highly advanced country. So many other things, caste, creed, political system, inciting somebody. So these, how to check and balances in order to not to they misuse these fundamental rights. Some check and balances were also there, and these check and balances right everywhere. Article 19 down to 21. 21, you see that Prevention Detention Act, the law has come. They have put some ceiling part. Now you cannot detain somebody without having given a chance to the person who are detaining. Then detention must not be more than 3 years. Then there must be some a committee will evaluate, and that kind of restrictions were put in all these fundamental rights, right from 19, 20, 21. These restrictions were also placed. So now this is a very period is very short. I think probably I must end it here. Huh?
So thank you so much. It was very enlightening, and actually, again, it's a very elaborate topic. But so we're grateful that you took us through it point by point and in a very precise manner.
That is how. But this is a very short period. Then we can anyway.
Yes, so there are a few inquisitivities which have been raised by your session, and so very general questions which people have raised. So first, there is a question from Mr. Shubham. So, sir, he asks with respect to preferential treatment, which is meted out. So he says, is our government policies like selective opening of a coaching institution for a particular community Can it be considered as a violation of Article 14?
In Article 14, it's a community. When it comes to the question of a community or religion as act itself, then I said that like in Article 29 and 30 provides that some preferential treatment in the sense. They say that once we give a right to a different section of society, and then their rights have to be protected with certain reasonable restriction, of course. But then preferential treatment, see that what it in Article 14, that even 19, why reasonable restriction has been put. Supposing there's an educational institution, supposing there's a post for an engineer, and we put that qualification, particular qualification, that he has to be a graduate in IIT and something. So these are the restrictions which they have put. Similarly, if some community is given some preferential treatment on the basis of maybe that's its contribution, supposing now see there's a general global university. The right to establish an institution there, that right is given with certain reasonable restriction. Now, tomorrow the General Global has created its name in legal, imparting legal education by dint of his, efforts. And somebody comes that, see that a person of similar nature comes that I want to establish one institution, but he doesn't have a background. And this person, particularly, he has shown it to the world around that, yes, he has a capability of delivering certain things, which is up to the standard which one can visualize and government can think of, yes, this is the education of some standard. So therefore, that kind of decision, executive decision or preference is permissible in this sense.
All right, sir. So I am assuming that Mr. Shubham has received his answer. If there is any follow-up, you may please kindly mention or raise your hand. I also request everyone, you have any questions, please, right now is a very good time. Just raise your hand or ask. So there is another question. This is from Mr. S. Sundar. So he asks, is there any provision for discouraging misinformation by the press?
That is what I've said. It's a provision of press council is there. This is the ultimate body to check the press media. They have to, as per the concept of the democracy, as per the concept of our constitution, even freedom of speech is given, freedom of press is not given. They do not have that right. So therefore, ultimately, what would have now they are dependent upon so many other things, the advertisement, and either tomorrow somebody raided their premises and all. Ultimately, the check and balances, there's a separate body is created, Press Council of India, and chairman of the Supreme Court retired judge is always a chairman, and they have their guidelines under this. So therefore, when there's a misinformation and campaign by a press, there is, but that our political system, we are what we call it, infant democracy in that sense. We may claim, so we may have a very tall claim, but still we are a democracy which is infant. Despite that, we have already had this 73, 74 years, I don't know, 75 years. But then we have not evolved in that because of political system. Initially, our politician, as per my experience, I have been in various forum for our GNU, all other kind of thing I've seen. Initially, when we had a politician, they were people of vision and some stature. They have got a vision, and they had a actual intention to do something good for the country. But slowly and steadily, because the billions of people, there's huge populations, how to manipulate these boards. Ultimately, there's a slowly and steadily, there was a degradation in the political, the politics. And once this degradation is there, The press become a victim through press, through caste, creed. You polarize people on basis of reason, caste, community. So many other things are there. So therefore, our press council people, those who are ultimate body to check the misinformation campaign by press in favor of or against anybody, has not yet been checked. There are so many cases time and again, but ultimately, in my opinion and my experience and what I have seen is no stringent action as such was ever taken against any press. Those who ultimately succumb to the power, power, whatever that may be at that particular point of time, because the advertisement, money, and that has become a prime thing today. We are not committed to our profession, vocation from heart. Apart from these press also, they are absolutely 99% press. They are basically focusing on making money, not that the contribution, not their responsibility they can contribute to this country and bring a healthy democracy and bring a healthy society. But that concept is lacking. It has totally money mind. So therefore, that the gentleman with the question is, which he has put to me, my answer would be that yes, there is a body called Press Council of India. They have certain guidelines. But as so far as the constitutional provision as such is concerned, as I have already said, that the freedom of speech they have given, you keep on telling, abusing everyone, but freedom of it was not made fundamental right. Maybe that tomorrow fundamental right is there. Some press like Pranab Roy and other, tomorrow NDTV is almost gone. Anyone whosoever comes in power, if any press media goes against that power, he is victimized, harassed, and everything is done. So therefore, that the concept has not evolved. People then started compromising the situation because there's no such safeguard and protection to freedom of a press as such, except that Press Council of India and its guidelines.
True, sir. And also considering how with the social media, the entire dynamics are changing with respect to what exactly is the freedom of speech and who is press. Because right now everyone wants to call themselves a journalist online, if we actually look at it. So
But
many channels are
somehow
trying.
that here, my opinion is somehow that the courts have also failed to check them. Courts have got enough power. Once their responsibility, they are the media. I said the basic concept of democracy was what? Opinion of the people. Opinion of the people is a democracy. And here, what is just the opposite? It is happening. It is opinion of the press. Well, last day they come up with certain opinion, and then there is a mechanism maneuvering inside as per this opinion in order to justify that the propaganda which is a press, the hired press is doing. So ultimately, it's eating upon the basic fabric of a society, I tell you. And I'm sorry, I used to go quite often because I was in various political movement also. Press Club of India, I stopped going there. And those days I had so many friends as a reporter, but now I feel that they have become uh, rather a burden on this society rather than revolutionary to revolutionize the thought process of the citizen of this country for their own betterment, for the betterment of the entire country. But now they have made themselves subservient to the masters.
Definitely, sir. So there is this comment from Mr. Basant Rai who says, but in case of press, people take their misinformation as genuine information. That is more damaging to society at large. Press is presenting their opinion as information. It's very true, actually. The idea of propaganda and also with respect to media management, how it is called, the concept of public relations. Sir, I actually had the opportunity of doing my master's in public relations from Mumbai University. So I've read about these things of how these things may be used and how they actually are used, how news is created and how it is made. So I am aware of that. But I understand that this is definitely one question which has actually, I think, sir, gotten a very clearer answer from you. So, also, sir, considering that we have limited time and there may be other topics that we may embark upon. So, very interesting things you have highlighted, considering all the political aspects of things. Also, we have also touched upon press and media. We've also touched upon communities and
No, but
how.
that's it. Everything revolves around the constitution. That constitution is the what Magna Carta we called it. Magna Carta is not in the sense Magna Carta is altogether different, but this is the basic inherent features of a human being. We made constitution for that purpose, and for that purpose, constitution it comes other things, society, all press, media, politics, everything comes in. That we as a system failed to adhere to the constitutional provision. Otherwise, these are all noble provisions. And with this nobility, if this the constitution is implemented, our country would be something different.
True. So hopefully it will eventually get in that direction which you have envisioned. So one final, I think a thought, question from my side itself. So with respect to the remedies which are laid down, or with respect to all the uh, for all the for the fundamental rights that we have. So it is enshrined in the constitution that if there is a right, then there has to be a remedy, and so we have such and such elaborate fundamental rights. And again, sir, we as advocates are it is said to be a learned profession, or we are supposed to be learned people. But considering the fact that most of the people, or say more than the billion people of India, they are not either as educated, or nor do most of the people choose to engage in educating themselves, uh, be it free legal literacy initiatives like these itself also. So, and then we come to the segments of society which truly are having to work for making ends meet. So, sir, what, as per your thought, is the efficacy of these remedies, and how exactly uh, are the people who are actually in the all the stratas, the various stratas, are they able to benefit from this?
It is, see, the why it's, when we come together and form a society as such, supposedly, we form a society as such. The basic purpose of forming a society is to development of each and everyone, and then electing a government. It is the ultimately the system, a government. Otherwise, society, if there was no requirement of a government, government would have never been there. People like earlier time, they could have done. But now somehow other, in order, the first thing is the basic concept is literacy is one thing which enlighten a person's mind, and he also becomes well aware of what is right and his necessities. So therefore, somehow the teeming millions are still in a bad shape. General parlance, I may say that I call it कीड़े मकोड़ों का हमारा देश अभी भी बचा हुआ है. If you go to the countryside, everywhere you see the nalas and everything. The condition worse than animals. Majority of the people are living animal lives, but then these privileged section of society, they are affluent, more affluent than American rich people, more affluent than European rich people. Where is the society thought process? This process must evolve from the politician itself. Those who have people have elected them to give us direction, how to evolve as a good, as a healthy country. So somehow the system, every system, I'm not blaming for one particular class. The entire system, we as a country, we as each and every individual have failed to achieve that, goal. We failed it to understand and endeavor and try to, put the efforts to bring this country as a healthy country. Like भले हम राष्ट्रवाद की बात बोल रहे हैं, where we are propagating those concepts of राष्ट्रवाद, but this is राष्ट्रवाद is just for the sake of misguiding people. But राष्ट्रवाद, the once I say the nationalism from my mouth, the word nationalism come, I never become a nationalism. because I have got many inherent contradictions within myself. I'm mostly focused about myself, mostly focused about my other things. So there are so many things that this dichotomous character, once we remove this dichotomy from our individual character, maybe that we can one day we can do. We are double standard कहते हैं ना, तो double standard हमारा society में बहुत ज्यादा है. Majority of people.
We only just hope and pray, sir, that with your blessings and with the blessings of all of our seniors, that most of us people who are coming in our generation and the generation which are coming after us, that everyone will have the opportunity to probably introspect with respect to how you have said that there need to be that there should not be double standards, and we should accept things for how they are. And at the same
Yes.
time, sir, how you said that at the end of the day, it is the constitutional morality which has to prevail.
Yes. That
So
this is much more than Gita, in my opinion. I mean, it's not atheist. I mean, I go sometime. Some superpower. I also wish them everything. But these documents, what they have done, people are society are leaders. This is more than Gita and Mahabharata. Why do we go Gita? Why we go for? If we let it in spirit, if we abide by our legal system, slowly and steadily, whatever the shortcomings are still in legal system would also get improved, and one day our society will be worth for living. Now today, I must not say everything, but now are we secure of anything? No one. From any aspect, you see, the old man, once old person becomes old, his wife becomes old, then his security is not there in the house itself. See, in this materialistic life, what is happening? The son is throwing his parents out.
definitely, sir.
Yeah.
So, sir, but again, I just hope and pray
So
that.
thank you very much. Thank you very much that having given that opportunity to me.
So it is. I really very humbly thank you on behalf of our entire team for
So
having.
thank you very much. Thank you very much.